Hello and welcome to another edition of Community Tapestry. My name is Napoleon Bell and I'm the Executive Director with the City of Columbus Community Relations Commission. And next to me we have, who do we have this year, this time? Miss Tony
Bell.
Wow, we have Miss Tony Bell as the co-host this time.
It's good to be here.
It is good to have you here, most definitely. Although it is awfully cold today.
Yeah. I'm not ready for this season, but you know, there's so many cool things going on, but there are people here who are so talented and good at what they do. They're going to warm our hearts.
They are going to warm our hearts with information, that is. But also, you know, it has heated up around the country with some of the issues that different cities and states are dealing with. And we're going to actually address some of those with our guests that we have here, because some of those are involving some critical incidents involving our police officers and community. And so we want to be able to give clarity to kind of the process of what happens from A to Z. So let me just start with introducing our guests. And to our left, we have Common Pleas Court Judge Stephen McIntosh. We'd like to welcome you to the program.
Thank you. Glad to be here.
Great. And then to our right, we have Deputy Chief Ken Keebler. I'd like to welcome you to the program.
Thanks for inviting me.
So this is something that is on the minds of so many people in our community, but also around the country, about the process of what happens when there's a critical incident that happens involving a police officer and the community. And so let me first turn to you, Chief Keebler. A critical incident. Now, we commonly think of a shooting involved. Well, let me first back up, ask you, what is your title, or what do you do within the Columbus Police Department that lends you to know about working with critical incidents?
Right. Well, first, I'm the Patrol South Deputy Chief. I oversee about half the division's patrol officers. But in addition to that, I'm the Firearms or Police Involved Death Review Board chairperson. And so that board is responsible for doing the administrative oversight over any police-involved critical incident, the review, the determination of policy, and the investigation into that matter. Okay,
so with that then, it's not just shootings then that you deal with as far as an officer-involved shooting?
Correct. It would be any officer-involved use of deadly force, or any situation where a citizen died in the custody or in the contact with the police department.
Okay, well, great. So that gives us the framework of what you deal with. So then let's expand. So what happens from A to Z? So let's say that there was a shooting, an officer-involved shooting, and the person died. What happens at that point? Walk us through it.
Sure. So the investigation really is broken into about three phases: an immediate phase, an intermediate phase, and a longer-term phase. In the immediate phase, the first thing, of course, is to ensure that we can get medical attention to any citizens or officers involved in that incident. So the securing of the scene by patrol officers at first will ensure that we can get that medical attention directed. As soon as that's accomplished, then we move into scene preservation, make sure we can preserve any evidence, any witnesses, or information that will be necessary for the follow-up investigation. Very shortly thereafter, getting that scene secured, who begins responding is our critical incident response team. That's a team of generally 6 to 12 experienced homicide detectives, their commander, their supervisors, will immediately respond to the scene and begin what is then a criminal investigation into the matter. Additionally, the chief of police, usually a deputy chief, the commander over that CERT team will respond as well and begin looking into the incident as a criminal investigation. Over the next 12 to 24 hours, that CERT team is going to be doing that investigation, collecting evidence, talking to witnesses, talking to people who've seen it, begin having discussions with the officers or the officers' attorneys, and begin that investigation. After that first 12 to 24 hours, move into what's called the intermediate phase, where the CERT team will come back and brief executive staff, give us an idea of kind of what happened here, some early indications as to what led up to the particular incident and what we know from it. Shortly thereafter, within usually about 3 to 5 days, maybe a little bit longer than that, maybe as long as 2 weeks, the officer will come in for an interview with that CERT team. And this is something that's fairly unique to Columbus, that we have a willing participants with the Fraternal Order of Police, the union that represents our officers, who are willing to bring the officers in to be interviewed in their criminal matter. Like any any person who's involved in a situation like that, they have Fifth Amendment protection rights and don't have to talk to criminal investigators during that investigation. What's unique to Columbus is that our officers do, and that they'll come in and have that discussion with the investigators.
Well, and let me just stop you. So that information could potentially be held against them.
It could be,
Okay.
absolutely, yeah, and that's what makes this process so unique. And we see in other agencies or other cities where they'll struggle with that when an officer will refuse to discuss the matter with the criminal investigators. We have this agreement where the officers will come in and do that initial statement with the investigators, which...
Is that something that's recent? Is that a newer?
No, that's been going on for actually well over a decade in Columbus.
Okay.
So it's fairly well established in Columbus that we have that agreement. So over the next approximately 60 days or so, generally, that the CERT team will complete that investigation into the criminal issue and then present, if it's a fatality, will present that situation, that investigation to the prosecutor in the county in which it occurs. Of course, Columbus is in more than one county, so it's not just Franklin County, but Delaware and Fairfield County as well. Present that information to the local prosecutor to determine if it should go to a grand jury or not.
Wow. Okay. So they've been interviewed by persons from the Columbus Police about what happened. And let me ask you this, and I'm going to back you up to just part of the process where shortly thereafter after the shooting happens and you're securing the scene or giving medical attention. So medical attention is given to both, whether it be the officer and also the person who was shot.
Yeah, whatever the case might be,
Right.
Shot, injured, whatever, yeah.
Okay. And then is there anyone, this is a pretty, with an officer being involved in a shooting, I'm sure that, there's a lot of things that are going through the officer's head, this, that, and the other, and being involved in this is a serious event. Is there someone that, does he get any help, and does he get any help with that? But then also, I also wonder about, are there people or persons that could be brought in also, because if there's family members that are there also?
Sure, very good question. So on the officers' part, we have what are called officer support team members. Those are members who have been involved in critical incidents in the past and have been through that process, so they had the experience and know what's going to come next, what kind of questions might be asked, just to provide some logistical support for the officers. They don't provide legal counsel. They don't discuss the particular case at hand. But they'll say the next step is you'll talk to so-and-so, or the next step is just to kind of help walk them through that, because that other officer has been experienced in that. And additionally, then the officers will usually reach out to their union for representation with an attorney, because again, it is a criminal matter at that time, and receive whatever legal guidance will be coming from an attorney in that respect. For the citizens, we certainly would reach out to family members to try to figure out what information can we give you at this time that can help bring you some closure, can help you understand what happened. We have to be sensitive to protecting the investigation, certainly. That is for the officer's benefit, for the citizens' benefit, for the family's benefit. We want to have an unquestioned investigation at the end. So for the protection of the investigation, that may decide what we can reveal to the citizens involved. But we have close partnerships with NetCare and other agencies throughout Columbus that can help bring professional counsel to a scene if necessary. We have contacts with pastors in the community who may be someone we can reach out to help the citizens involved as well.
Excellent, excellent.
I think my question is, how do you keep your sanity in this process? Because, I'm sure that you can empathize with the family who has just lost a loved one, whether it's the officer or the citizen. How do you keep your sense of balance and sanity, knowing that this is a traumatic situation every time you have to deal with it?
For everybody involved.
Everybody.
Sure. So I think for the officers in the division, for people in the division, we take that responsibility very, very seriously. And so I guess we kind of focus in on the work. So what needs to happen to ensure that everybody involved has a clear picture of what happened to this at the end, so that we can give the community the answers that they may be seeking, so that we can provide for the needs of the officer involved, if there are needs, or the officer's family involved. We just get into that work mode where we'll just take care of our responsibilities and make sure that we focus on what we've been called to do, what we've been called in this profession to do, which is to obviously bring closure and care to that process.
So is there some way that you are able to connect with the rest of the community? Because there is this perception that, especially if there is an action, you've talked through the 3 steps, but there still is the perception by the community that if there is a fatality at the hand of a police officer, that you're all going to collude together and tell the same story.
Right.
So what kind of comfort or connection are you able to give the community so that they have a better understanding that that's really not what happens?
We would open up those investigations at the proper context when the criminal matter is completed, or when there's no longer a protected document or whatever else. We release those records are available to our community to look at, to dive through, to leaf through, and to ask their own questions and look at those and say, does this sufficiently answer the questions that have been asked? And if not, then they could come back to the division for some more information, certainly. But we take very seriously as well the important role of being in the community, meeting with groups who are asking these questions, preparing information to give to our community to let them know how these processes work. Recently, I had an opportunity to meet at a local church and walk through this process and say, here's how it happens. Because I do think it's very important that the community understands how this process works ahead of time. We've seen in some other communities that there's some questions that maybe they're making up as they go along, a sense that maybe they didn't have a good plan here as to how we're going to investigate a situation like this. We feel we have a good process. We feel it's one that's been developed over the last decade or more. We feel confident in that. And so we want to share with the community in advance through programs like this and other opportunities to say, here's how it's going to happen. So when you hear that we're presenting it to the grand jury, when you hear that we're in this 2-week window where the officer hasn't spoken yet, why is that? We're saying in advance, this is how it's going to go. This is the time for dialogue if there are community concerns as in that process, and we can maybe make changes to it if there are concerns with it. But it's important to understand we didn't make this up with the next incident. We established this a long time ago.
There's policy and procedures that you follow each time. So this is good information for the community because of the fact that then as you're going through it, they go, okay, they should be doing this now, or they should be doing this now. And if something's different, then they go, oh, well, wait a minute, you're supposed to be doing this.
So one thing we've heard in some other communities is that why has the officer spoken yet? It's 3 to 5 days. Why hasn't the officer given a report? And so we're saying now that this is why the officer has criminal protection rights, rights as afforded by the criminal process, because at its core, what we may have is a homicide. That's what the coroner will call it. It's not a murder. The homicide means that another person caused the death of somebody else. And there's underlying that a self-defense argument, which is made in other citizen-involved shootings, where a citizen may shoot somebody and make the same self-defense claim. So you have those expected criminal protection rights. So when people in the community wonder why we haven't had that discussion with the officer yet, this is why, because he has those protections. But we have this procedure where he's going to come back in and give us that statement at the appropriate time.
Excellent. So we talk about this process and getting to the court system. So let me turn to Judge McIntosh, and so take it from here. The shooting has happened, and they've done their internal investigation. That information has been given to the court systems. What happens when this goes to the prosecutor's office? What happens from there?
Well, generally speaking, once a packet is provided to the prosecutor's office, they review it and make a determination if they have enough information. I would assume they go back to law enforcement, say we may need to talk with this witness, may need some additional information, some additional evidence, and I'm assuming also that they're waiting for lab reports and things of that nature. Once the prosecutor's office is satisfied that they have all the information that they need, then it does get presented to the grand jury. Now the grand jury is, most folks hear of a jury, and a grand jury is different than what you see in a courtroom.
Okay, how so?
Well, the grand jury is selected for the sole purpose to sit, and grand juries in Franklin County generally sit for about 2 weeks, and then they'll rotate them through. And the prosecutor presents every case that they have available and ready to the grand jurors. And the purpose for the grand jurors is to decide whether or not there's probable cause to file a criminal charge. The prosecutor will present the evidence. They'll decide which witnesses they need to present the information to the grand jurors. And then the grand jurors will make that determination whether there is a no bill, which means that they don't believe that there's sufficient probable cause or enough information to file an indictment, and the indictment is then filed at that particular time. Now, the proceedings themselves are not open to the public. You don't have an audience there. The only persons generally present are the prosecutor, the witnesses, and the grand jurors. On occasion, you may have a defendant come and testify, but even in those situations, their attorney is not allowed to sit into the grand jury proceedings either. and the only person asking questions during this process is the prosecutor.
Can you tell the audience why it's like that?
Well, I mean, the process is set up, I mean, because understand, I mean, the grand jurors are selected from the same roles as jurors that we have in our jury trials.
And how many are there?
15 by statute, or as little as 9, I think, based upon the criminal rules.
Okay.
And the process is set up this way so that you have, again, individuals from the community coming in, listening to the information and the evidence that the prosecutor is presenting, and making that determination. And again, it's a probable cause determination. Okay, they're not sitting there trying to decide if this person is guilty or not guilty.
Right.
What they're doing is evaluating the evidence to decide if there's enough evidence there to file a criminal charge. Ultimately, if a criminal charge is filed at a later time, the determination as to guilt or innocence will be decided either in a trial or if the person decides to plead guilty.
What's the time frame of all this? You know, if information is handed over to you and then they determine, okay, we're going to go before the grand jury, is this a process? Is that process a week long? Because you know how you hear some cases are 3 weeks, 4 months. Yeah. How long is this process typically?
Well, you know, it really varies based upon the type of case that you're talking about. And then it varies also based upon how much information a prosecutor believes he or she needs to get the indictment. They're not going to try their entire case in front of the grand jury. So they're not going to bring in every witness that has been identified in the case, generally speaking. Now, in a high-profile situation such as a police-involved shooting, they may bring in a little bit more information in those situations and circumstances, and so it may take a little bit longer to present it to the grand jurors, and a little bit longer to get all the information together before they're comfortable to actually make the presentation as well. But it really varies from case to case, and depending on how much information the prosecutor believes he or she needs to get that indictment.
Well, let me ask you this, because there's been claims about issues within the grand jury process, and having the prosecutor's office provide the evidence. And you talked about, you know, he or she provides evidence in regards to the case, but not all the evidence because of all the witnesses, what have you. Is there something in that process that the information or statements could be presented in a way that's not as favorable for one or the other? I mean, so is all the information brought forward in an unbiased way and laid out there for the grand jury to kind of decide? Because you hear people talk about this, and well, this just doesn't seem right with the prosecutor's office doing this.
Well, I mean, the prosecutor's office, in presenting the evidence, is presenting the evidence again for the jurors to make the determination if there's sufficient probable cause. And because of the fact that they're not trying their case, you know, sometimes there may be some information about the weakness of their case that may be presented. But generally speaking, what they're trying to, again, to see, okay, do we have enough information? Do we have enough evidence right here to actually get the indictment charged in the case? And because, again, they're not trying the case, they're not going to go through all the pieces of information, all the pieces of evidence that they have. I mean, that ultimate determination will be made at the trial itself.
Right. So I think that when I think from a community standpoint, it's always the question in the community's mind: Did the case get thrown before there could be an indictment? And that's, you know, and I think that's what you're answering now. How do you continue to build trust? I'm hearing what the police department does in their advocacy and communications. What, if anything, does your office do to help educate the public on how processes go and to communicate with them so that they don't fear the process or make accusations that aren't really based on truth?
Well, part of the difficulty, at least in the state of Ohio, as it relates to the grand jury process, the grand jury process in Ohio is secret. You know, unlike in Ferguson, where the prosecutor kind of went through all the evidence that was presented. It's only in rare circumstances that any portion of that information, the testimony that occurs in the grand jury, is made public.
Is that good? Is that bad?
Well, I mean, I don't know if it's good or bad. I mean, it's the process that's been in place. And again, if there are questions about that process, there's a way, there's means to get access to that information. But the evidence itself is available. I mean, it becomes a public record if there's if there's a no bill, and then I assume the administrative process itself is completed. Then whatever information or evidence was available for that process is a public record at that point in time, and most of that would be made available.
Does the public do a good enough job with looking at the information that's available before they make, cash in on an opinion?
I mean, as to, I mean, sort of looking at it sort of after the fact? Mm-hmm. I don't know. I mean, because again, part of the issue is you take a look at the information or evidence that is available, and then having an understanding and appreciation of what the law is. Mm-hmm. Just because someone was shot doesn't mean that a crime has occurred, because it needs to fit in.
And that's hard. That's hard for people to take in.
I mean, it may mean that someone didn't necessarily follow policy or procedure, but that doesn't make it a criminal act. Because again, if you talk about taking a homicide and turning it into a murder, okay, there's certain like the state of mind, that it's an intentional act, a purposeful act to cause the death of another, and in particular, law enforcement person that's doing his or her job. I mean, it would be rare, I mean, to see something like that happen. And so that's why most of the time, if you're looking at these types of cases, then the question is, well, is it a manslaughter? Is there something that the officer did or didn't do that caused the death that was legally or criminally improper? And so just because, you don't like the facts, just because the facts don't look good, just because of the fact that it was terrible what occurred, doesn't mean that those facts fall into a criminal charge.
Well, let me ask you this. So when you're trying to find out probable cause, are the jurors then given instructions to probable cause to murder or homicide, or do they have could it be manslaughter? Could it be something else, a lesser charge? Is there that
Do they have that information?
Do they have that information as far as that we're looking for probable cause for one of these charges, or is it always a murder charge?
No, they're provided with all the available options that are available under the law, where this scenario could potentially fall into which particular category. So they're going to provide to them the wide range from potential murder charge to a manslaughter charge, maybe, I guess, a negligent homicide, but anything based upon the facts as the prosecutor understands them to be would be presented to the grand jury.
Excellent. We've got about 5 minutes, and I wanted, and thank you so much, Judge. I want to turn back to you because this doesn't stop. So if there's a no bill, mm-hmm. and so the officer is not going to be indicted, it comes back to you. Correct. And so what happens then?
And in a case that hasn't happened in Columbus, but if it were a true bill and there was a trial, it would still come back to us. Okay. So the judge really set up the next phase of this, which is that we will conduct an administrative review, and that's what the Firearms Death Review Board is responsible for. A team of 9 commanders who serve on that board, and several of them will weigh in on this particular case to determine if policy violations occurred in this particular shooting. The judge is right in that it could be a criminally okay shooting, but still outside of policy for various reasons. So there may be no crime that occurred, but we may say, yeah, no crime occurred, and we're good on that, but there was a policy here that you violated. And so that board is responsible for taking that investigation now that it's done at the criminal side. The same investigation, the same package comes back to the board to then review administratively for those policy violations. So the board will then, a 3-member panel of that board will meet, discuss, and I can tell you I've been on some of those boards, and there's robust dialogue as whether this particular shooting was or was not within policy, and then send their recommendation to the officer's chain of command for a final determination.
Could that determination be up to and including firing that officer?
Could be, absolutely. Just as there are a wide range of criminal options available, if an officer was found to be outside of policy in a shooting, the chief has a wide range of discipline options available as well. It could be a true honest mistake in which discipline is minor or just enough to say, you know, hey, we made a little mistake here and we believe we can train you to a value and then we can move forward. You know, your experience, your history, and your future is that you'll be a good officer. There could be a situation where so far outside of policy that termination would be the only reasonable recommendation. But that wide range of options is available to the chief.
And where can people go if they want to get more information and if they would like to connect with either of you to get more information?
Well, certainly, as the judge said, these are public records, so the division has a public records office, which is open and responsive to those requests for investigations. Also, our public information office is available as well.
Now, can they also find out, if it came back and they found out whether it was within policy or out of policy, can they request those records to find out?
Absolutely.
Okay.
Columbus has a very wide open public records law, and the judge indicated that those records, when they're done on the criminal side, in the administrative review, they're available for review. Even while that review is ongoing, our division will release those records at that time.
Okay. We have time for one last question, and I kind of want to go back to you, just because I wrote it down. How are the grand jurors selected?
Well, jurors in Franklin County are selected through the voter rolls as well as through the BMV. So that's where these jurors come. So
they don't know if they're going to a grand jury process or just a regular juror process?
No. They'll know that they've been selected for grand jury. Okay. Jurors at least in the common pleas court, are selected for 1 week or one trial. So their service could be relatively short. Grand jurors could be on for anywhere from 5 to 6 months. I mean, they're not going to serve that entire time, and I think the pool, I just talked with our administrative judge earlier today, the pool is about from 70 individuals that are called in for grand jury duty and made aware of the fact that they would be utilized over that 5 to 6 month time.
So they could be utilized a couple times during that.
Well, they'll be, if someone gets selected to sit on a grand jury for the next couple of weeks, okay, they're going to sit on multiple cases. Okay. And that's multiple cases per day.
All right, well, we got to wrap it up. We're running out of time. Phone numbers that they can call. I need more information. Well, who can they call, Judge?
They can give me a call, and I'll give them whatever information I can, but it's at 525-3550 is my number. 3550?
Yes. Contact the judge. And
my number is 645-4691. The Public Information Office is 645-4593.
Excellent, excellent. Well, I appreciate both of you. Both of you being here. This has been some great information, and I'm sure very helpful and hopeful to the community at large to be able to better understand the process during one of these critical incidents. Thank you so much for your time. And we'd also like to thank you for being a part of this segment of the show, and we'll be right back after these words.